So, welcome back, ladies and gentlemen. There was a slightly small time break in between because I got to get used to a new software. Now let's see how that works. Welcome back to our International Business Law class. And we're going to proceed with the major part of what we call international business law. And that is the first word, international. To get used to it and to have some kind of an example case, we start with the mail delay case again. But this time, please take your time and read the text you just see right in front of you. It's going to be an international case between Germany and France to make it not too far away and to give you some kind of impression what that could be like. So please stop the presentation for a while and read the case first. Well, the questions on the case are about the same as the questions were when we were talking about the German mail delay case. But now there is an extra question before that. And the question is, which laws have to be applied in that case if S, the seller, can only be sued in Germany? So it's a little different case now. It's more international. And we got to see how that works. Basically, this is the strategy with which we work on case studies if we talk about civil law case studies, and we already practiced that one or two times, so you know how to use that. In international business, it's a little different than that because, well, the one thing is it's international now. The question basically stays the same. Who wants what, of whom, based on which claim, that's the same. But others than before, every court will ask, does that case have international relations? Because if it has international relations, such as our case, there are minimum two of the international law systems involved. In our case, the French one and the German one. And now the question is, which laws are we going to be applying? More or less likely, the French party will insist to use the French laws, and the German party, because they know that much better, they will insist on using the German laws. So there got to be a decision for that if the parties cannot agree at all. And the first question is for the courts. And this is what's interesting for us because we try to predict what the court decision would be like. Are there international relations in the case? If no, it's pretty easy. Then we are doing the German case mail delay and apply the German civil law book, and we call the BGB, that's the Bürgerliche Gesetzbuch. But what happens if there is an international aspect in the case? Then the next question will be, is a foreign court to be deciding? Now, since we are a German university, a foreign court for us means it's a court somewhere else but in Germany, or is a national court going to be deciding? That scheme actually applies to any lawsuit worldwide. This is why it says example given down there. For the reason of the fact that we are in Germany over here, we use a German court. Now, what is the German court going to be doing in the next step? It's the national court, the German court. They will apply what we call international private law. The German expression for that is internationales Privatrecht. I don't like either one of the two expressions, the IPL and the IPR, international private law or internationales Privatrecht, because they're misleading. There is nothing like an international private law or something like that. And the headline you can see above is much more precise. We're talking about a conflict of laws, basically a conflict of law systems, because we could apply the French law system or the German law system, and it's a conflict. Which one are we going to be deciding? And every nation worldwide will have its own rules to decide that conflict of laws. So it's not international private law, it's a national law telling you which of the international law systems the court will have to apply. In Germany, that is situated in Article 3 of the Introductory Act to the German Civil Law Book. And again, we're using the German abbreviation for Einführungsgesetz zum bürgerlichen Gesetzbuch. It's EGBGB, okay? So the court will look at the Article 3 of the EGBGB, and then we will find out that there are 3 different possibilities which could be the consequences applying that. So first of all, before we start working on that and before I start telling you about Article 3 of the Introductory Act to the German Civil Law Code, you have to read it, and you have to read it very closely. And believe me, no matter whether your mother language is German or English or any other language you can think about worldwide, this text is complicated, even for people having spoken German from their first year of life on or something like that. Now really read it. I mean it. Read it. Okay? So let's have a look at that article. I would now advise you to stop the presentation again and really read that article very, very closely. And after you've done that, I'll try to emphasize a couple of the words in there and a couple of the sentences, okay? So stop the presentation now and read. Are you back? You read the article? Good. So the first word we will have to focus on is unless. Unless, and then we have immediately applicable rules of the European Union or rules in international conventions. This is further down with number 2. Unless one of these is applicable, that means they have to be applied first. If none of these 2 possibilities will apply in a case, then we are allowed to use the conflict of laws article of our Introductory Act to the German Civil Law Code, Article 3 EGBGB, and the following ones, 4, 5, 6, 7, and so on, okay? So if you think you got that message, we will come back to our scheme of the method. A German court, a German judge would be deciding cases like that. So we are at a German court, we said that. We said they have to apply their own international private law system, which basically is the wrong expression. It should be called a conflict of law system. And now we have the first part of the EGBGB. And since it says unless, we have to start with the very last, or let's say the for a last sentence, and that is Article 1, Chapter 1, number 2. This talks about international conventions, because that's very logical. If we have international conventions, we have to apply these first. Because if we would apply the national ones first, nobody ever would apply the international ones. So the international conventions, the international law sources, must be the highest and the strongest. And if one of those exists, then we have to apply those, not the European ones, not the German ones, only the German ones, okay? Or that means not the German ones, but the international ones. I'm very sorry, because that was a failure. The international conventions, okay? We have to apply those, and that's it. Now, the only one we will be working with in this case study, that could be the CISG. It's an abbreviation for the Convention on International Sale of Goods. And would you now please get a copy of that, because we might need it in the next 10 minutes, okay? But first, before we move on with that, we move on with Article 3. So the German court will check that. Is there some kind of an international convention? If we don't find one of those, the second possibility, do we find European regulations? Same logic behind that as it was before. If we have international law sources, let it be the international ones of the United Nations, or let it be the international ones of the European Union. Well, we have to apply those first, because otherwise they're useless. Everybody would just apply his national laws, and they would exist just for the fun of it, or for the beauty of it, I don't know. But it doesn't make sense, okay? So we have to look at these 2 regulations And if you now want to stop the presentation, I would actually encourage you to do so. Have a look at these two European regulations, Rome 1 and Rome 2, because Rome 1, that is the EU regulation about the applicable laws for contractual lawsuits, contractual law cases, whereas Rome 2 is the law source, the regulation of the European Union for what we call statutory claims. That means claims which are based on rights, law of torts, or unjust enrichment, or agency of necessity, okay? So if you want to stop a little and just read the headlines, maybe read a little of the introduction of that, and that's fine. Remember, we said it says unless at the very beginning of Article 3, and unless means if none of these two is applicable, then we are allowed to use the German law source for that, and that is our international private law system, which is a contradiction itself. And the very last sentence in Article 3 of the Introductory Act to the German Civil Law Code. And there's basically for business law aspects, it's different for law of heritage and different for law of families, such as childhood, marriage, divorce, and stuff like that. But for the business law part, there's actually only one relevant article left over, and that is Article 43 of the Introductory Act to the German Civil Law Code, and we will be coming back on that article a little later. Okay, so this is what the German court's going to be doing. They will apply one of these three possibilities and then figure out now which laws will I have to apply. And these three possibilities will lead the court to some kind of substantial law now. The French civil law book, the German civil law book, the civil law book of Singapore, or to some kind of prejudice-based system or whatever. And then that court, the national court in Germany or in France or in Ghana or in the United States, one of the states of the United States, they will have to apply either their own law. In most cases, judges will be very happy if the conflict of law system leads them back to their own national substantial law because they know that best. Or if it's not like that, then they will have to apply a foreign law system. That means you do research on the internet, you try to find the law sources, you try to find out about the jurisdiction in the foreign country, which laws you now have to apply. Okay, got it? I again would advise you, kind of force you to do so, but now go through that scheme again and again to make sure you understand the logic behind it. Once you understood it, international law cases are pretty easy, at least as long as it's only about defining which laws are we going to be applying. But you can do it like that. But it is complex, and one got to be sure which of these three possibilities will I have to apply and how do I work my way through that. Okay? So give you a little time to go back. And if you think you're fine and you're ready and you looked at it 2 or 3 times, we move on. Okay, so still we are with the question, which laws have to be applied in that case? Okay, that is, if we look at our conflict of laws methodology, that is the first question, the international aspect, Article 3. And after that, after you found out that it's an international law system, you got to qualify the type of claim we will be working with. And we again go back to Article 3, because all of these 3 possibilities which are mentioned over here, I got to switch off my printer so it doesn't make any noise. All of these 3 have a different type of claims they're actually dealing with and working with, and that might be a good information for you and good news, because that is something you already know. qualification of claims only means we got to figure out which type of claim that is. And these are our good old 5 different types of claims we looked at before in our lesson. So we have contractual claims, we have claims based on rights in rem, and we have that group of statutory claims, which are agency of necessity, law of torts, and unjust enrichment. Okay? Another good news for you, we can have some kind of an equation. Because every time you qualified some kind of a claim as being contractual or as being unjust enrichment or as being part of rights in rem, then you know which law source you will have to apply to solve the question of conflict of laws, which laws of which country will have to be applied. So when we talk about contractual claims, you will have to go to the Rome 1 regulation and do that now. Have a look at it. Have a look at the first, let's say, 5, 6, 7 articles of Rome 1, and you will see that there are a lot of different contract types mentioned, and every time there is a type of contract mentioned, it says, for the sales contract, we use the law system of the place where the seller is situated. And then we are going for the rental contracts, for the labor contracts, for the agency contracts, and so on, okay? So it goes like that. And we have one specific international law source for a specific type of contracts, which is just still quite a common one. Even we do live in a world of services, let it be electronic or let it be services such as hairdressers or restaurant or something like that. But the sales contracts still are a huge part of world economy, and they are regulated in articles of the CISG, the Convention of International Sale of Goods. If we have questions about property rights or whether somebody has to give up the possession or transfer the possession to somebody else, this is the only part in which we apply the German Introductory Act to the civil law book, the EGBGB, the EGBGB, and that's Article 43, okay? Have a look at it as well, and that's a pretty easy rule because it says we always apply the laws of that state in which the goods, the things are situated. Okay? But that's very reasonable because if I have products delivered to the United States, Texas, and I want to sue somebody from over here in Germany, you can easily imagine that the authorities and the courts in Texas will not be very impressed by decisions made by a German court because it's their law system, it's their area. So if we talk about property rights, we better ask the country in which the things are situated. Otherwise, it would be very complicated and might cause international conflicts if we insist of our own point of view. And it's the same thing with the other 3, and that's again good news because all of them, agency of the necessity, law of torts, unjust enrichment, they all are regulated in Rome 2. Stop the presentation at that state, have a look at Rome 2, have a look at the first 10 articles over there, and you will see the method the European Union and the legislation of the European Union has been working to define which law is going to be applied on a law of tort case, which ones on unjust enrichment, and so on, so on. Okay? Good. So now the court does that. It applies Rome 1 or the CISG or Rome 2 or Article 4 of the Introductory Act to the German Civil Law Code. And then after that, it comes back to what we looked at before, and it figures out which laws can be applied. Okay? So that's easy, and it might be your own laws. Good luck for the court. Or it might be the foreign courts, so then they will have to find out what laws do they have over there. and find out about the interpretation in that country. Maybe you forgot the situation of the international mail delay case. Meanwhile, would be kind of reasonable because you read a lot of articles and you heard a lot about the systematic of conflict of laws. If you don't remember the international mail delay case anymore, just read it now, stop the presentation, go to the first part and read the case again, because now we're going to be applying what we just learned on a case. So this is going to be a case study, an expert opinion on an international civil law lawsuit, court suit. Okay? Stop, look, and then go back. We know that the German court, because the assumption was that the seller can only be sued in Germany, that the German court will start with Article 3. The Article 3 has 3 different possibilities. Talked about that less than 10 minutes ago. And the one which is most interesting for us is the one down there, which is now to be seen in red. Number 2, rules and international conventions insofar as they have become directly applicable in national law. The first part is easy, rules and international conventions. Okay, you got to look for international conventions and very good law sources for that. These are the home pages and the pages of the United Nations, and you will find a lot of lists over there and data files, and you can look for any type of international convention we have. But there is a little other part at the end of that, and that says, insofar as they have become directly applicable in national law. Now, what does that mean? I'm pretty sure that most of you have learned about that in school, but this is a kind of a description you never heard about. But you heard about another word in the legislation of every country, in Germany for the Bundestag, for the Senate in the United States, for the Duma in Russia, whatever, if they have to introduce foreign international conventions, they have to ratify that. And the act of ratification makes an international convention, such as the CISG, the Convention of International Sale of Goods. The ratification makes it a Russian law, a German law, an Italian law, and a French law, okay, if the states actually ratify that. So once we have the assumption, or we think there could be an international convention, such as the CISG, we will have to look that up and see, is it applicable in our case? And the interesting thing about what lawyers would call a modern law source, well, the CISG is more than 50 years old, but for us, it's a kind of modern law source, is that at the beginning of all of these sources, all these international conventions, we have a part which is called, which will talk about the applicability. So these international conventions, they define the area in which they want to be applied themselves. And that means the geographic area, that means on which type of contracts and lawsuits, and that means on which persons. Okay, so there is a very precise definition of that. And I would advise you, whenever you have to work with a foreign law, and that is for everybody something else, because we have different nationalities, whenever you apply that, first look at the structure of these laws and then see whether they say themselves something about their own applicability, okay? So for the CISG, and you should stop the presentation again, get a copy of the CISG, because now we have to look into the CISG and see whether that would be applicable on our case, the international mail delay case, okay? Hopefully you got a copy now, okay? So at the very beginning, we have an article. Well, we have a lot of articles in there, but we have an Article 1A of the CISG, and it says the CISG will be applied on cases in which both parties of a lawsuit, of a kind of a legal struggle, are located in contracting states of the CISG. Wow, that's great, but the question we have now is, what are contracting states? I'm pretty sure that most of you, because you're the generation of the digital natives, as we call you, already picked up your mobile phone or your tablet computer or whatever you have and start looking what are the nations who have signed, which have signed the Convention on International Sale of Goods. It's a pretty long number. It's more than 80 states in that. And I'll give you some information about that in a couple of minutes. But before that, before we look up the states and we try to figure out whether, according to Article 1, letter A of the CISG itself is applicable, we should ask another question, and that is, did the parties explicitly exclude the CISG? And looking at Article 6 of that convention, you can see that would be possible. So if the parties don't like the CISG for any reason, because they think that the Swiss laws are better, or the German laws are better, or I don't know what, the Finnish laws are better, they could do that and instead of that introduce that. So then the CISG, if both parties don't want that, will not be applicable on a case. In our case, we don't have any information about that the parties wanted to exclude the CISG. But since they didn't have a decision, the court will have to find out themselves. And so the court goes to the internet. What you see over here is a nice picture, which I copied at the homepage of the Pace University, the Law Pace University in New York. And they're pretty fast, and they have that nice picture for us. And 2002 December is kind of wrong, because I looked it up in March, so that is a typo. I'm not going to correct that for that video now, because that would be an awful lot of work. And now look at that. We have two countries in our case, Germany and France, and now we go through the alphabetic order and we find F. France is part of the CISG, and we move on two flags further on to the right, Germany. Okay, so both Germany and France are part of the CISG. Wow! So now we got the answer. The CISG has to be applied. And from the point of view of conflict of laws and international private law, that's the answer. You don't go further than that. For us, we got to move on. We got to move on because the parties in our case want to know whether the CD players have to be delivered or not, and they will not be very satisfied if we only tell them, well, we are going to be applying the CISG. And now we have to follow the same structure as we did in the German lawsuits, in the German law cases. The first thing is, does one party, the plaintiff, have a claim on whatever he or she wants, in our case on the CD players? And now you got to look through the CISG, and it's a little like in a cooking show right now. I prepared something for you because I thought you would be asking for that. And we look for the claims, and there are two different types of claims. Some for the buyer and others for the seller. That's obvious, and they have different interests. The one wants goods, the other one wants money, so they have to have different claims on that. And then we have the primary claims, such as possession and property, that the buyer wants that. And if it goes wrong, he might be interested in damages, reduction of price, delivery of substitute goods, or whatever. And we find that in the Articles 45 to 52 of the CISG. Very same structure with the seller, because he or she first of all, wants payment. But if they don't get the payment, or they get the payment too late, or not the correct interest rates, or whatever, they might refer to the question, oh my God, do I get damages for that? Can I ask for interest rates because I had to take a loan for all of that? And that's it, okay? Good. Actually, ladies and gentlemen, that's all you need to work on the mail delay case. And from now on, it's up to you, okay? You work on the mail delay case international and try to create an expert opinion the way we did in the national German mail delay case. But you will have to answer both questions. The first one, which laws are going to be applied? Well, you just follow my structure, and then please try to write it down, because if you have to write an expert opinion yourself, it's more complicated then, and you might find out that's not that easy now. And then you go to the second part, and you already know the claim. You just look at the list we had there before, you pick out the claim which might be applicable in our case, then you talk about the prerequisites for that, you check it, and you try to figure out, and this is another part of the law sciences, whether the answer of the CISG is a different one than the one we found out when we were looking at the German Civil Law Code, the BGB, the Bürgerliche Gesetzbuch, okay? Try to find your way through the CISG yourself, but I'll give you a little hint. The articles you might be needing are the articles 7 to 24 of the CISG, okay? Just read them, okay? You will find out what it is, and try to follow that logical sequence lawyers and judges would apply. Is there a claim? What are the prerequisites for it? And go on, and then check the articles you think which are applicable, article by article, sentence by sentence, word by word, and you definitely will have a result then. I think that these cases are pretty fun, so have fun with that. Still, it's 2020 when we take that video. Corona is on, so stay healthy, please. And see you next time. To be continued. See you then, ladies and gentlemen. Bye-bye.